One last note about the personal transaction requirements, and I wish I could have got this in before I ended the last hour, but we'll be okay. But one last note about these personal transaction requirements. In paragraph G, it says we must disclose any other interest in a transaction you may have, such as if you're working with or representing a close relative. Is the main thing they're trying to get there. You'd have to disclose that relationship. How do you do that? Well, you got to write it in the contract that buyer is brother of agent or seller is mother of agent. Whatever that relationship is, you must disclose it. And it just has to be somewhere in the contract. Now you notice here it's not nearly as specific as it was if you had to disclose yourself as the buyer or the seller. So if you're representing yourself, remember that has to be on the first page of the contract, all capital letters, underlined and in bold, right? But here it's just saying, but if you're representing a close relative, that is something you need to disclose, have to disclose. But you don't have to do all that underlined, bold, capital letters and stuff like that. Just got to be somewhere in the contract that must state that. Now, one thing I will note here, first of all, well, what is a close relative? I don't know. I mean, I know what it might be for me, but does that mean that you might agree with my definition of a close relative? Some people just says mama, daddy, brother, sister. Some people say out to first cousins. Some people say anybody related to you. I mean, so how do you know when is it considered a close relative? One of the things I would suggest here, look in your company's policy manual. Hopefully, the broker in charge has defined what a close relative is, at least for those operating within their office. If they haven't defined it, that's something I'd be asking about for sure. Because if it's not defined by the company or the office, and there's an investigation for some reason, now you're leaving it up to the investigator to define what a close relative is. So, but now having said all that, here's what I would suggest, and I will tell you what I'm about to tell you is way more than what the law requires. I'd just rather, I've seen people get in a lot of trouble for not disclosing enough, but I've never seen anybody get in trouble for disclosing too much. Okay, so so my kind of policy is, if I have any kind of relationship with the person I'm representing, other than just strictly professional, if I have a relationship, then I just disclose what that relationship is. Put it in the contract. Typically I find nobody even cares, but at least you can't try to say I didn't disclose something. I put things in there such as seller is neighbor of agent. Buyer is high school friend of agent. Even though I may not have seen them in the last 20 years, but 20 years ago we was friends. But anyway, so my point is I just disclose any relationship I have with that buyer or seller, anything other than just strictly professional, just so there's no issues. All right, moving on. Next thing we have to talk about are these offers to purchase real estate. And I've actually had people ask me, well, what's the difference between an offer to purchase and a contract of sale? There is no. You make your offer in the contract of sale. You'll get a contract of sale. You'll fill it out, as the buyer. Obviously you're filling it out based on what you're willing to offer the seller. Send it to the seller, and assuming they accept it and sign it, then that offer becomes the contract of sale, right? So it's not like it's two different documents here. I just want to be very clear for those that have never purchased real estate before. But we need to talk about these offers. First of all, the law says all offers must be in writing. Y'all pay attention to that. All offers must be in writing. Y'all, I assume you know what must means. Y'all, that is not just a suggestion. So, and by the way, what about a counter offer? Does that apply? Well, is a counter offer an offer? Yes. Y'all, so when we talk about offers, y'all, we're talking about counter offers as well. All offers must be in writing. So should you ever call the listing agent and say, hey, look, I know your seller's asking $300,000 for this house, but do you think they would consider $290? You can't do stuff like that. That's an offer. You can sit there and you can try to tell me that's not an offer, but it is. It is an offer. And it's a verbal offer, and that's a violation of license law. So why do agents do it? I get these calls all the time where basically they're wanting to make a verbal offer just to see how my seller will react to it. Well, first of all, I'm not taking a verbal offer to my seller because you have to put all offers in writing. Now, usually I try to be professional about it. And when they call and ask me stuff like that, I'll just say, well, you know what? That's a good question. How about put that in writing, shoot it to me, and I'll go find out. Okay? But until it's in writing, I am not going to bother my seller. There are a lot of reasons for it, to be honest with you, but the main reason here is, that's a violation of license law. So why do agents do it? You ask any agent, they typically they know this. It has to be in writing. So why are they calling, making these verbal offers? Believe it or not, it's because their client pressured them into doing it. Where your buyer will just say, look, just call them and ask them if this is something they would consider. If not, then why waste the time writing all this stuff up? Just call them and ask them. There's no harm in that. Just call them. They'll cave in. So, just because you were obeying your client, do you have to obey everything your client says? If it's legal, yes. But what they're asking to do in this case would not be legal. So, just beware. Number 2, we must promptly deliver executed documents to all parties. In other words, once your client has signed a document, then you have an obligation to get that executed. Once they sign it, it's considered executed. You got to get copies to all parties. We all have a right to know what we're dealing with here. Number 3, got to make sure we include all the terms and conditions. Obviously, I'm kind of paraphrasing things. In your book, it gets into a little more detail into what all this stuff means, and you can read about it. But we have to include all the terms and conditions of the contract. But what does that mean? Well, when you're filling out a offer to purchase or the contract of sale, the good news is it's already pre-printed. The document's pre-printed, so it's not like you're writing something from scratch. All you're having to do is fill in the blanks. There's blanks all throughout the contract that you have to fill in. Well, what should go in every blank? Something. Something needs to be there. You cannot leave a blank. That's what they're talking about here. If you leave a blank and you send it to me, what am I supposed to think about that? Are you wanting me to fill it in for you? I don't know. I'm not a mind reader. So if you send me something, there are blanks in the document, how am I just supposed to assume what that's supposed to mean or not supposed to mean if you leave it blank? You can't do that. But people say, but this is really not even applicable to what we're trying to do here. Okay, well then what do you put there? NA. Y'all, that means not applicable. Y'all put something in the blank. Okay? All right. And then number 4, y'all, we got to make sure any changes or modifications, y'all, that's considered a counter offer. But all changes you make must have the initials and dates by all parties. Y'all, we talked about this in the contracts chapter, but y'all, here's where you see it in the law. Y'all make sure you have the initials and dates by all parties. Y'all, that's critical. Not only for test purposes, but for real world purposes. And notice it says all parties. You can't have a married couple buying a house together and think just one of their initials is sufficient. No. All parties have to initial and date. Okay? Now, when it comes to completing agency agreements, now first of all, y'all, obviously in your book, in your material, you'll see a fair amount of reading material there, and you need to read it. But a lot of it we actually talked about, again, I think is in a much earlier chapter. But y'all, when we're completing agency agreements, y'all, we know they have to be in writing. But in number 1, what it's saying here, well, basically, what number 1, just saying everything has to be in writing, okay? And basically, number 1 and number 2, everything has to be in writing. So if you're going to be representing the buyer or the seller, then they have to sign an agency agreement. Y'all creating that agency relationship. If they don't want to be a client and you're still willing to work with them, obviously that would make you a transaction broker in the transaction. At the very least, I would highly recommend you get a compensation agreement. I think you'll probably see something about that here in a little bit. But y'all, just make sure all the documents are in place. If they want to be a client, you better make sure they've signed a written agency agreement, because without that, and you start providing these professional services, and by the way, does your opinion, suggestions, is that considered a professional services? Yes. If someone asks your opinion about, well, Frankie, what do you think? Do you think it'd be a good idea to put this in the offer? I can't, unless you're my client, I cannot answer that. That's considered a professional service, because if you do provide that kind of information, now you're you're at risk of creating an implied agency, where now you're giving that buyer or seller reason to believe you're representing them, even though there's nothing in writing to say so. And that's implied agency. And we know in South Carolina, implied agency is illegal. Now, in some states, it's legal, but not in South Carolina. It's not. If you're going to be a transaction broker, this is where it's saying, you need to at least have them sign a compensation agreement. If it's a client and they sign an agency agreement, typically, within that agreement, you'll also address what the compensation will be. How much will your client pay you or whatever. But if they're a customer, they're not signing an agency agreement, so therefore you don't have a compensation agreement either. But we do have a form. It's just called a compensation agreement, where you can use this, even though it does not create the agency relationship. The buyer customer or seller customer is basically saying, but if you'll help me in a non-professional way to get this deal closed, then I would agree to pay you X amount. Well, you need that in a written agreement. It's called a compensation agreement. Now, I'll just tell you, that sounds a lot easier, I believe, than it actually is. Because, if somebody is refusing to sign an agency agreement, to be represented, I don't see many of them agreeing to sign a compensation agreement. I don't see it. But hey, if they sign it, then so be it. There you go. But if you are a transaction broker and you don't have a compensation agreement, y'all do not expect to be compensated for anything you do. Y'all, the next section of law here is dealing with modifying offers. Y'all, meaning counter offers. Y'all, if you modify an offer, y'all, if they offer you $300,000 and the seller counters back at $325,000, then y'all, they've modified that offer. Y'all, that's considered a counter offer. And again, counter offers must also be in writing. Now, I do get this a lot. Well, first of all, is there a difference between making a counter offer and negotiating? Yes. In fact, I will tell you, I don't know how do you know what to counter until you've sat down with the other party and negotiated. Now, you can't, you shouldn't be doing, well, I won't go there. Let's say, for example, I've got an offer offered me $300,000. They've also written into the contract that they want my seller to pay $10,000 in closing costs for the buyer. Obviously I'm just making up numbers, but well, that means if my seller accepts the offer, and just considering those two things alone, my seller's only going to net $290, because of the $300, now they're asking us to pay $10,000 in closing costs for the buyer. So you're really not going to get $300. You're only going to get $290. Well, maybe my seller's already said, I will not accept an offer where I do not net a minimum of $295. We'll just go with that number. Well, obviously the $290 is not going to satisfy the seller. He's already told me that. So I now have an obligation to contact the buyer's agent and say, hey, in the way I would do it, I'm always trying to be very positive. But one, I said, look, I want to thank you for the offer. I will tell you, I think I'm pretty confident we can make this offer work, but there are some things we're going to have to take a look at. We cannot accept it the way it's written. So I know in my mind we're $5,000 off of what I know the seller has already told me they would be willing to accept. So I guess my first question might be, well, buyer, when I say buyer, buyer's agent, how important is the closing cost to the buyer? I mean, how big a deal is that? And obviously, if it's not a big deal, then we might say, well, how about we agree to do $5,000 in closing cost and $300,000 in sales price, which is what you offered to initially anyway. I think that would put us where we need to be. Now, obviously, if that would work for the buyer, now I've closed the gap. I've gotten that net to where my seller would want to be. But again, I'm not making we're just negotiating. We're trying to figure out how to make this work for both sides. That's negotiating. But typically what you're going to hear, at least in this market nowadays, when I ask them how big a deal is the closing cost, more than likely, they're going to come back and say, Frankie, it's critical. In fact, I can just tell you, either the seller must agree to pay these closing costs or this deal won't work. They can't get the loan if the seller will not agree to pay these costs. Okay, well, so we know we can't do closing costs. But I'll tell you, here's what a lot of agents do. Instead of negotiating like what I'm just talking about, they'll just automatically counter back, saying we'll pay $5,000 in closing costs. They just counter back. And what you've probably done by doing that is killed any chance of this deal closing. The buyer cannot do that. They cannot. It's not a matter whether they want to or not, or be willing to or not. They cannot. Their lender has told them, if the seller does not pay these costs, we're not giving you the loan. So you countered the very thing that cannot happen. It's not going to work. So that, y'all, this is why you need to talk to the other party, which is what we call negotiating, to try to figure out where we need to go with this, or how we can make this thing work for both sides. But after talking to them, now I know closing costs, that is not going to be an option. That one is not negotiable. Well, then the only other thing we're going to be able to do, buyer, if my seller agrees to pay the full $10,000 in closing costs, then we're going to have to increase the sales price to $305,000, right? Yeah, and there may be some other ways, y'all, depending on what other provisions in the contract, what those are. But y'all, we got to figure out how to bring that net to where it's going to be satisfactory to my client, and hopefully will work for the buyer as well. So we're just trying to negotiate and talk about things that might work and things that just will not work. And then once we get to a place where, okay, I think we can make that work. I think that'd be okay going to $305 in sales price if they'll agree to pay the full $10,000 in closing costs. Y'all, now I know how or what to counter. But unfortunately, y'all, I guess the art of negotiation has just disappeared, at least in this market, because rarely is there any negotiating. It's just straight up counter offer. And typically the counter offer they made is not going to work. And there may have been some other things we could have done if you'd just asked some questions. We could have made this deal work, but because you just countered, and you countered the very thing that will not work, you've killed the deal. Yeah, you see it all the time. So yes, counter offers have to be in writing, but that should not be confused with negotiating. Okay, you can negotiate by phone or in person or however. But anyway, all right, beat that up enough. Y'all, again, we got to make sure we include all the initials and dates. Y'all, any changes you make, all parties must initial and date them. Don't forget to fill in all the blanks, right? Make sure you include all the terms and conditions. Means you fill in all the blanks. Make sure you deliver executed copies to all parties. And then, y'all, this next bullet, y'all, you need to pay attention to. This is very important, both for real world purposes and test purposes. But here the law is saying if an offer or counter offer is rejected, y'all, and that happens a lot, the party that rejects the offer or counter offer must sign what we call a rejection form. And that form must be returned to the other party within 48 hours. Y'all, that is not a suggestion. Y'all, and I hear this a lot. Y'all, I've had other parties reject offers we've made, and then I ask them for a copy of the rejection form, and they said, well, our policy is we don't do that. We told you it's rejected, that should be sufficient. Well, it's not sufficient because the law says you must sign a rejection form and send it to the other party, and you must do that within 48 hours. I remember that 48 hours, by the way. Y'all, there's actually a rejection form that the state, y'all, the Real Estate Commission came up with, and you have to use that form. You can't just put it in an email or a text and say, well, I did it in writing. No, it's got to be on the approved state form that was provided by the Real Estate Commission. All right, y'all, and then the last bullet here, y'all just saying offers may be transmitted by electronic means, in other words, email. Nothing wrong with that. So when you're submitting or delivering these executed documents to other parties, you can submit it by email. No problems there. All right. And then in paragraph 7, y'all, and by the way, here is talking about when the licensee's purchasing property, again, you're representing yourself as the buyer. You're looking at buying property and you're representing yourself. But this particular topic is really dealing with if that property was actually listed for sale by your company. Okay. So what we're getting ready to talk about is if you're making an offer on a property for it yourself that was listed by your company. Now, if it was listed by any other company, none of this that we're getting ready to talk about will apply. So just make sure you understand that. Number 7 here is just saying, again, you must disclose your interest. And again, because you're representing yourself, means you got to disclose it on the first page of the contract of sale, all capital letters, underlined and in bold. Just a review. But look at number 8. Again, because the property you're making an offer on was listed by someone else within your company, then you must also disclose to the seller that they do not have to pay any commission if I buy the house. That's a written disclosure. You got to tell the seller, not only am I a licensed real estate agent, I'm a licensed agent in the same company that has your house listed for sale. That's a big deal there. And because of that, seller, you do not have to pay any commission. Now, I will tell you, that law was implemented as of the date of this video, probably 3 or 4 years ago. But y'all agents don't like this anymore. They don't like this law. And honestly, I don't see where it's that big a deal. I really don't. But agents have tried to make a big deal out of it. So, if you tell the seller, because I'm licensed in the same company with the agent that actually listed your property, you don't have to pay a commission. Do you think the seller, now it doesn't say the seller can't pay the commission. They can pay the commission. You just have to let them know they don't have to pay it if you buy it. Well, do you think the seller would go ahead and pay it? Or do you think they would refuse to pay it? And pretty much everybody I ask, their response is no, nobody's going to pay it. If they don't have to pay it, they're not going to pay it. Well, I don't know that I agree with that. Look, first of all, I've never been in that situation personally, but I think it has a lot to do with how you make the offer. If it were me, if I were the buyer, again, obviously I'm an agent, I would certainly disclose just exactly what the law tells me to disclose. I'm a licensed agent, and I'm also licensed in the same company that you've listed your house for sale with. And seller, because of that, you do not have to pay any commission. And then I'd have them go ahead and sign that disclosure, that acknowledgement, acknowledging that I disclosed to them you do not have to pay any commission. Now, once they've signed it, now here's my offer. Seller, I would be willing to buy your house if you're willing to pay the commission. Now, obviously, you don't have to pay the commission, and I ain't got to buy the house. So that's up to you. And in my mind, I'm thinking, well, they've already agreed to pay it, and if they sell it to anybody other than me, they're going to have to pay it anyway. So would you rather go ahead and pay it and let me buy it, which now we can go ahead and bring this deal to a close, or you want to leave it out there for however many more weeks, waiting on somebody else to buy it, and you're still going to have to pay the commission? It's up to you, seller. Which one do you want? I think they'd pay it. I honestly do. But anyway, whether they will or they won't, make sure you remember that disclosure. Not only for test purposes, and I can assure you they'll ask you about it, but also for real world purposes, you better not forget to make that disclosure. And then paragraph 9, basically what it's saying here, agency agreements that are over 1 year are no longer enforceable. First of all, I can't imagine anybody signing a buyer's agreement or a listing agreement for even a year, much less anything over a year. I can't even imagine that. But obviously people are doing it. So, the law basically had to put some kind of bumper here, basically saying, it didn't say it's illegal to do it for more than a year. They're just saying it's not enforceable for anything over a year. So I suggest you don't be listing properties for more than 1 year. Again, I can't even imagine who would be willing to do that, but in case they would, make sure you don't do it. All right. The next thing we need to take a look at is really dealing with property management. If we're going to be managing residential or commercial property, what you're looking at right here, obviously you would have to create that agency relationship. But the agency agreement that we use in property management is just called a management agreement. And there's verbiage in that management agreement that once the agent signs it and the owner signs it, then that would create the agency relationship. But what you're looking at right here are just some things the law requires at a minimum must be included in that agreement. There has to be verbiage in the agreement that addresses these things. Obviously, well, it may not be obvious, but there's going to be a lot more stuff in a management agreement than just this. But these are the things that are required by law. You must include in that management agreement. Obviously you got to have names and signatures of all the parties. Make sure you can identify the property that's going to be managed. How do you do that? Well, you can you put the address, but you never want to just go with just the address. You want the address. I would also include the tax map number and the legal description of the property. There's blanks there to fill it in. You need to fill all that information in. And hopefully all three of those descriptions will match the exact same property. All right. The method of compensation, that has to be addressed. How much are we going to get paid? How do we get paid? When do we get paid? All that information needs to be included in the agreement. This next bullet is saying you cannot include an automatic renewal clause without the option to cancel within 30 days. This was, again, a fairly recent change in the law where most, if not all, property managers, they might have it for 1 year. Now, management agreement for 1 year, that's common. That's very common. But if you're working with a seller or a buyer, it's not. But management agreements are very common for a year. Again, you still can't go over a year, okay, or it's no longer enforceable. But what they would have here, they might say that, all right, they'll have in the agreement that the management agreement will expire on December the 30th. But then they would also have verbiage in there that says, even though it's scheduled to expire by December 30th, owner, if you really want it to expire on December 30th, then you must notify me in writing 30 days prior to December 30th. You got to give me 30 days notice that you do in fact want it to expire. If we don't receive that written notification, and a lot of them even require it to be by certified mail, just to make it more aggravating. But if we don't receive your notice of your intent to terminate, then it will automatically extend for another year. And then once it extends, you're stuck with it. You're bound to it for a whole nother year. That's what we call automatic extension or automatic renewal clauses. I hate those things. You see them in all types of contracts, unfortunately. But at least now in South Carolina, and when we're dealing with management agreements, this is not These automatic extension clauses have not gone away. They're not illegal. But when it comes to management contracts, they're saying if you're going to have an automatic renewal, you must include the right to cancel the contract with 30 days notice. So even if it does automatically renew, they're not bound or stuck with it for a whole nother year. Now, if they want to, that's fine. But if they want to terminate it, then all they have to do is give 30 days notice once it renews, and then they can get out of it that way. So I would remember that. They can get out of it with 30 days written notice. Excuse me. Some other provisions, again, must be in that management agreement. It says compensation for future lease renewal must be in capital underlined letters on the first page of the agreement. What they're talking about here, and this was actually a big problem for a while until I think we've fixed it with this law. But this was primarily a problem for commercial leasing agents. With commercial leasing agents, they would, they're dealing with long-term leases, like 5 years, maybe even 10-year leases. Well, what would happen a lot of times is, you'd get a owner of a strip mall or whatever that would hire a commercial leasing agent to, find tenants, lease out all the space, get these 5-year, 7-year, 10-year leases. And then what they would do is after the first year of the management agreement, they would just say, no, I'm terminating the agreement. Well, that's a little unfair. If I'm that leasing agreement and I just put a tenant, a really good tenant in your space, and they signed a 10-year lease, and now you're terminating or will not agree to extend my management agreement, that's unfair. And maybe I need to address this too. Property managers or leasing agents, the way they get paid typically, now this is not every single time and for every situation, but it's very common that the compensation, they will agree to some percentage of the rental amount that the agent will receive every month. Just for example purposes only, maybe me and the property owner agreed that I'll receive 10% of whatever the rental amount is per month. That will be my fee to manage the property, right? So, if it's $4,000 rent a month, and 10% of that would be $400. So my fee is $400 per month for that lease. Well, what happens when the owner decides to terminate or not renew my management agreement after the first year? You've got another 9 years worth of rent coming in from a tenant I secured for you. That was unfortunate when things like that would happen, but basically what this provision is saying is if that happens, look, the owner does not have to renew the lease. Not the lease, the management. They do not have to renew the management agreement, but you still have to pay me whatever percentage we agreed upon for the duration of the lease I secured for you. So you don't have to have me manage the property, but you still have to pay me X percent of that rent every month for the next 9 years, right? Again, if you're going to have that, it's saying you must put it in capital underlined letters on the first page of the agreement. Make sure they understand it. So just by terminating the management agreement does not terminate my compensation when it comes to future lease renewals. Okay, that's what they're really talking about there. And then, any terms and conditions of the tenant rental arrangements must be addressed. Agreement cannot contain an automatic clause binding the seller to list with the management company. Y'all, what they're talking about there, again, y'all, prior to this law being put into play, y'all, property managers would put in their management agreement that if the owner of the property decides to sell the property during the time that I'm managing it, then you must list it for sale with me. You got to let me sell it. That is now a no-no. You cannot do that. That would be an illegal provision. Now, look, could the owner agree or allow you to list it and sell it for them if they tried to sell it? They can. But what the law is saying is the owner is not, they do not have to list it with the management company. They could just list it with some other company because this is a completely different transaction. So you cannot have a clause requiring them to list with the management company. That's what that's saying. All right. The next thing we're looking at here is dealing with managing multi-unit rental property. Now, first of all, what is a multi-unit rental property? A lot of people get confused by this. In fact, a lot of people say, well, 2 or more would be multi. Well, that's not what they're referring to. I don't know that this is a big deal for test purposes, but I do want you to understand it because you need to understand this. But when we talk about multi-unit, that's considered 5 units or more. So if you've got a quadruplex, which a quadruplex means there are 4 units, that is not considered a multi-unit property here. It had to be 5 units or more. Probably like an apartment complex, right? That's what we're talking about here. So if you're managing multi-unit property, obviously you have to have a license to manage the property. And in paragraph A, then in paragraph B, it's just saying one licensee can manage multiple multi-unit rental properties. So in other words, I'm not just bound to just one apartment complex. I could manage as many apartment complexes as I want to. Anyway, that's what that's saying there. But then in paragraph C, and again, we're still dealing with multi-unit rental property. Paragraph C has identified things that an unlicensed employee can do, things they can do without a license. You don't need to try to memorize all of these things here. I don't believe that's necessary, not for test purposes, but for example, maintenance. Could I hire a maintenance person to go fix things when they break? Yes. Well, does a maintenance person have to have a real estate license? No. So that's what they're talking about here. There are some activities or functions that I can hire people to do for me and not require them to have a real estate license, okay? But one of the things I do want to just point out, and you'll see why this one is important, is I think it's like the 4th bullet down, where it says they can show rental properties to prospective tenants. Now, you can do that without a license. You're just showing the rental properties to tenants without a license. But note, what kind of property are we talking about right now? Multi-unit rental property. This only applies if it's a multi-unit property, 5 units or more, okay? Because the next thing you see in your material, you should see where it's talking about for all other types of real estate transactions. Again, we're still talking about managing, and previously we were talking about multi-unit property. But now we're talking about all other types of properties, which would be anything less than 5. So a single family home, a duplex, triplex, or quadruplex would fall into these other types of real estate transactions. Here, they've listed some things that an unlicensed employee cannot do. So if it's not multifamily, it's any of these other properties, and you hire someone and they're not licensed as a real estate agent, they list some things here they cannot do. And y'all, again, I'm not going to sit here and go through it. Now, look, you need to read them, okay? But I'll bring out a couple. Y'all, look at number 5. You cannot conduct or host an open house or manage an on-site sales or leasing office. So you got to be licensed to do an open house. You better be licensed if you're working in a sales office or a leasing office. But number 6 is the one I want you to pay attention to, where it says you cannot show properties for sale or lease other than the multi-family property. Y'all, please pay attention that not only for test purposes, but for real world purpose. Y'all see people that they're going to get in trouble over this. They're going to get in trouble, so be careful with this. Y'all, if it's not a multi-unit property, you cannot have an unlicensed person or employee meeting people at the property to show it to them, or meeting inspectors and stuff like that. Y'all, that's a no-no. Y'all, the only time you can get away with doing stuff like this and not be licensed, again, is if it's a multi-unit property. Y'all, I don't want to keep beating it up, but I'm just telling you, you better make sure you get it, because that's going to be a big deal for you. All right, hopefully that makes sense. And then, y'all, the next thing you see here, y'all, the law actually identifies certain types of records that are not required to be maintained. Now, we were talking in a previous hour, y'all, about the y'all, you got to maintain all documents for a minimum of 5 years. Y'all, hopefully you remember that. But here are some things that the state is saying you are not required to maintain. Y'all, text messages, y'all, instant messenger, voicemail, voice recording, social media posts. Y'all, those types of things are not required to be maintained. Now, it doesn't say you can't maintain them. It just says you're not required to maintain them. Y'all, I will just tell you, I think it's a good idea, especially anything in like a text message or email or even this instant message. Y'all, I would print those things out and I would put them in my file. I do. Y'all, I save every email from a client, y'all, in case there's any misunderstanding or disagreement where your client said, well, I never told you to do that. Well, yes, you did. You absolutely told me to do that. Well, no, I didn't. Now you got he said, she said. And y'all, and I promise you, when you get into a he said, she said, you're going to lose unless you could prove that you're right. So y'all, I always keep it, but at least for test purposes, y'all, you're not required to maintain those type things there. Okay.